Hi, this is Matt Baum at the American Foundation for Equal Rights, and here's a clip of Judge Smith at the Ninth Circuit Court of Appeals on December 8th, trying to get Prop 8 proponents' lead counsel Charles Cooper to answer a question he really doesn't seem to want to answer.
I begin with this proposition, that if at any time during his tenure on this case, Judge Walker desired to marry his partner, then he would have occupied precisely the same shoes. He would have stood in precisely the same shoes as the plaintiffs before him.
But we don't have any evidence in this record of that, do we?
Your Honor,
do we? Please answer my question.
Your Honor, to the contrary, we do have evidence that a reasonable person with knowledge of all the facts that isn't what I ask you. Do we have anything in this record, any evidence that that's what he desired to do? You all talk about if he desired, but I didn't find anything that said that's what he desired. Your Honor, what we do have in the record is that he was in the same kind of long-term same-sex relationship that the plaintiffs before him were.
In other words, the answer to my question is no, but we got some other stuff you think is important?
Hi, this is Matt Baum at the American Foundation for Equal Rights, and here's a clip of Charles Cooper, the Prop 8 proponent's lead attorney, getting all worked up during arguments at the Ninth Circuit Court of Appeals on December 8th.
But if Judge Walker was ruling that he has a constitutional right to get married to his 10-year-long partner as soon as his ruling is affirmed, if it is by this court, then if this court does not says what they urge you to say, that that's just fine, this will be a signal and dark day in American jurisprudence.
Thank you, Mr. Cooper. Well, let's hope, however it comes out, it won't be a dark day in our jurisprudence.
Hi, this is Matt Baum at the American Foundation for Equal Rights, and here's a clip of the Prop 8 proponent's lead counsel, Charles Cooper, at the Ninth Circuit Court of Appeals on December 8th, admitting that marriage equality wouldn't actually harm any heterosexual marriages. And that's why the Prop 8 proponents want to hold LGBT judges to a different standard than straight judges.
But I do not believe, and we have never maintained, and we have disavowed the notion that any individual marriage is going to be negatively affected. The institution, yes. And in years and decades down the road, we believe those effects will be manifested.
I don't know about presently. I have a hard time understanding how, if the institution of marriage is immediately negatively affected, that doesn't affect the people who are married.
Your Honor, we haven't even said that we believe that it's likely that it would be immediately negatively affected, but we do believe that the institution over time would be negatively affected. But that would not translate into an individual heterosexual married judge having a direct interest in the outcome of the case.
Hi, this is Matt Baum at the American Foundation for Equal Rights, and here's a clip from the Ninth Circuit Court of Appeals on December 8th of David Boies explaining why the Prop 8 proponents, by arguing that Judge Walker's ruling should be vacated, are creating a double standard that would unfairly oppress all minority judges.
Even if he had an obligation to disclose an intent to get married, he doesn't have an obligation to disclose a non-intent to get married. And if you look at the pernicious effect that such a rule would have, because you would be singling out, you'd be creating the double standard for minority judges that the courts in the city of Houston, United States against Alabama, and a whole series of cases that we've cited in the court have said would create an intolerable double standard. Because a majority judge, a heterosexual judge, may feel passionately about preserving the institution of marriage. Does that judge have an obligation to volunteer, to come forward, and tell the parties what his views of marriage are and his views about the institution of marriage and what the effect would have? If not, then what you are doing by the rule that Mr. Cooper advocates, simply creating a double standard, and it is going right in the face of the cases that have repeatedly held that minority judges, just like majority judges, are presumed to be impartial.